Sally, that's just not going to be possible, because when old James died and left a mere $100,000 to Hamish, to my client, he couldn't have been well advised, and the estate's worth $2 million. There's no way that's going to survive, and as the only child, Hamish is entitled to a lot more than that. So,
well, Gord, I didn't draw the will, so that, you know, I'm not part of that. However, Ruth is my client, and we're talking about a wills variation action that you've brought. So, yeah, she's stuck with this right now. It's pretty clear if you get into the facts and you look behind it that the son is doing fine. He's been very adequately provided for during old James's lifetime.
Just a second. I'm not sure that the facts are agreed to here. My client is in his 30s. Ruth is James' second wife. They were only married for, what, 11, 12 years?
12 years,
well,
12 happy years.
Well,
yeah.
They may have been happy for him, but they weren't very happy for Hamish, okay? And he didn't get along with her, and for good reason. I mean, she is a bit of a problem. And so they're probably not going to get along in the future, and I don't care what James thought of that.
Well, Gord, I think you're going to see at discovery that my client is a gem of a witness. The judges are going to love her. She's credible. She's a sweet, sweet lady. She's 65. She was utterly dependent on old James. I mean, this is a perfect case, honestly. I mean, the judge is going to say, lady, your husband provided well for you for good reason.
But just a second. Your client has an obligation, a moral and legal obligation, to make adequate provision for his spouse and for his children.
Old James is not my client. Ruth is my client.
All right, well,
I beg to differ. And let's just go back into that, okay? Hamish got the business, was given to him, set up by his father, and look, he blew it. I mean, the business folded. Old James poured money into that kid for many, many years. $100,000, he's lucky he got that much. And I've got witnesses who are going to be very clear about James's generosity to Hamish during his lifetime.
You can have all the witnesses you want. This doesn't survive the smell test. I mean, $100,000 out of $2 million for an only child? I mean, what are you thinking? The Beaverton case was really clear that there is a moral obligation. It has to be discharged.
Yeah.
He's not discharging it, and you know, your client is gonna reap the benefits of his misbehavior.
Well, luckily Hamish isn't on the streets now. He's made a go of things for himself, and my client's glad about that. She has no ill will toward him. But believe me, this is will's variation. This isn't a philanthropy exercise.
No, look. James thought, apparently, according to Hamish, that somehow your client was going to make provision for Hamish in her will. All right?
Well, she plans to, and I have every expectation. My client is very, very credible. She has no other relatives. She thought that she and Hamish got along just fine, and I don't see why.
It's not, you know, you can't transfer the obligation that James had onto Ruth.
I mean, agree. I agree.
Okay.
Well, I'll tell you, he's really blown it now by seeking a will's variation. And I mean, now, if any goodwill that she had, that's pretty well down the drain.
But, sorry, there has to be a variation.
60 to 75% of the estate varied in his favor. That's
come on.
bizarre.
She came into the relationship with at least a couple of $1 million of her own. This woman is going to be riding high. She can flip the bird to my client and never deal with him again.
Antiques and jewelry, they don't go out as a couple of $1 million. I don't know where you're getting your facts from, Hamish. This is all going to become clearer at discoveries, I'm sure. But
well, we will
it's just unfortunate.
Full financial disclosure to
worries.
see whether there has been any adequate provision made for Hamish. And as far as I'm concerned, it hasn't. He's going to have $1.5 million. He needs at least 60, but we say 75% of the estate.
You know, judges still do listen to facts, Gord. They still listen to facts. Morstan made that clear. They are not there to second guess the testator and the testator's intention. So, I mean, fine.
So I was counsel on Morstan, okay? And I happen to, at least at the trial level, and it's distinguishable on those points. I mean, we've already talked about it. Anyhow, there's no point in talking to you about this if you're not open to the possibility of my client being properly adjusted for in the situation. And if you're simply saying that's not going to happen, why are we wasting our time?
Yeah, properly is the operative word, isn't it?
Right.
Fairly and reasonably. So I guess really the battle's drawn, and I mean, let's go. Away goes a lot of the money that goes to both of them.
Not
or
a lot of
either
money.
them,
It might be $75,000 aside. Out of $2 million, that's a chance worth taking.
Yeah, right. Okay, Gordon.
Great, thanks, and you too. So what you just saw up there up front was a bit of a demonstration, and the first part of this course is actually an interactive one that's going to involve each of you. It's going to require you to work in small groups that probably most easily divide up in terms of tables that you're sitting with, which means you're going to have to join a friend over here if you can. And for those of you online, it's the same exercise. You can be doing it yourself as well. What we wanted you to do is to, having seen the demonstration that counselors, the two legal counsel, Sally and Gord, were doing, to try to characterize, if you could, in your small groups, the type of process that you saw witnessed here as you were watching the demonstration. What were some, if you could try to, within your group, identify some of the key features, the types of interaction that they were making, the behaviors, any skills, if you saw any skills, if there are skills that you were there that you can identify, whether negative or positive, to try to kind of get a focus in terms of what type of interaction was happening between these two lawyers.